Welcome to Xavier Law Essence, the place where we give you premium legal tips to help you make informed decisions, live informed life, and discover the very best version of yourself. Let's talk about alternative dispute resolution today, focusing on arbitration and mediation specifically. Now, the Arbitration and Mediation Act of 2023 has made provisions on how to go about the processes of mediation and arbitration in Nigeria. This forms a unified legal framework that will give guidance on how to practice mediation and arbitration in Nigeria. So, for those who are into commercial practices, who are into contractual relationship, the Act applies to all commercial transactions. And commercial transactions or activities that fall within the definition of what commercial transaction means have also been outlined or listed under the Act. This Act can also be applicable in international transactions. That is the provision of the Act. Okay, so the essence of this Act is to ensure expeditious disposal of cases, is to ensure that there is timely intervention and proceedings are always attended to without any form of delay or undue delay. Now, when you look at the court system, the traditional method of dispute resolution, which is litigation, that it is time consuming, either because of delays that occur on the part of the parties or the part of the counsel due to factors that may be out of their own control, due to non-appearance in the court, moving of motions, as well as adjournment of cases. So these factors make the process prolonged. Now, the coming of the Mediation and Arbitration Act is to encourage the practice of alternative dispute resolution. That instead of going to the court to spend all the time and all the years, instead of keeping parties in court longer than it is necessary, parties to commercial transactions experiencing dispute in their contractual relationships can actually choose to embrace alternative dispute resolution. The Act has made it very, very, very flexible. Yes, so that you have a choice on who will sit on your arbitration tribunal. Now, it is not a hard and fast rule that when you go in for arbitration that it must be a sole arbitrator. The parties can decide whether they want a sole arbitrator or they want more than one arbitrator to sit on the arbitration tribunal. The parties have the right, it is that flexible, yes. The parties have the right to choose who will appoint the arbitrators. So it's not like it is something that arbitrators will just appear from anywhere. No, you have a right to have a say. Alternative dispute resolution gives you, the party, access, gives you a connection with the case. Unlike the traditional litigation system where you just sit wherever you are and that the lawyer is advocating for you. This process gives you connection with the matter before you. Okay, so parties can choose to draw up a separate document that will list out the terms on how the arbitration system is going or proceeding will take place. They can choose to include that a particular appointing authority, a particular entity will appoint arbitrators for them. They can also decide that, yes, I will appoint two arbitrators, you will appoint two arbitrators, and then maybe the next, the remaining one, another appointing authority can help us to do that. The parties can also choose the venue. So you're talking about your convenience while addressing your problems. Okay, so this is a unified legal framework to encourage people to embrace mediation, to embrace arbitration, especially in commercial transactions, especially in commercial relationships. Okay, it has its own benefits. So that's why we tell you nobody will give the law to you the way we give it as Xavier Law Essence. Here we give you premium legal tips to help you make informed decisions, help you live informed life, and discover the very best version of yourself. We'll see you again.